Wisconsin has a well-defined set of lease termination rules that every landlord and property manager in the state needs to understand. The governing law is found in Wisconsin Statutes, Chapter 704, along with the Administrative Code, ATCP 134, which adds consumer protection requirements to the mix. Let's start with the basics: how notice periods work in Wisconsin. For month-to-month tenancies, either party must provide at least 28 days written notice before the end of the rental period. That's not 30 days, it's specifically 28 days, and it must align with the end of a rental period. So if rent is due on the first of the month, the notice must be received at least 28 days before the first. Getting the timing wrong can invalidate the notice entirely. For year-to-year leases, Wisconsin requires a minimum of 28 days notice before the end of the lease term. For fixed-term leases of less than 1 year, no notice is technically required to terminate at the end of the term. The lease simply expires. However, it's still best practice to provide written notice to avoid any dispute about whether the tenancy has converted to a month-to-month arrangement. Week-to-week tenancies require just 7 days' notice, and the notice must expire at the end of a weekly rental period. Now let's talk about termination for cause, the situations where a landlord needs to end the lease early because of a tenant's actions. Wisconsin provides several grounds for early termination. For non-payment of rent, Wisconsin allows the landlord to issue a 5-day notice to pay or vacate. If the tenant doesn't pay the full amount owed within 5 days, the landlord can proceed with eviction. This is one of the shorter non-payment windows in the country, which benefits landlords who need to act quickly on delinquent accounts. For lease violations other than non-payment, the process depends on whether the violation is curable. If the violation can be corrected, like unauthorized pets, noise complaints, or unapproved occupants, the landlord must give the tenant a written notice identifying the violation. The notice varies depending on the lease term. For month-to-month tenancies, the landlord gives a 14-day notice that the tenancy will terminate at the end of the rental period if the violation isn't corrected. For leases with a definite term, the landlord gives a 5-day notice to cure the violation. For violations that are not curable, or for repeated violations of the same type, Wisconsin allows the landlord to issue a 14-day unconditional quit notice for month-to-month tenancies. This means the tenant must leave within 14 days with no opportunity to fix the problem. For fixed-term leases, the landlord can seek eviction through the courts based on material breach. Wisconsin also allows termination for criminal activity on the premises. If a tenant or a member of the tenant's household engages in drug-related criminal activity or any criminal activity that threatens the health, safety, or peaceful enjoyment of other residents, the landlord can issue a 5-day unconditional quit notice. On the tenant side, Wisconsin recognizes several grounds for early lease termination. Tenants who are victims of domestic abuse, sexual assault, or stalking can terminate early by providing written notice along with documentation such as a protective order or police report. The tenant must provide at least 28 days' notice, and the landlord cannot charge early termination fees in these circumstances. Active duty military members can terminate under the Federal Service Members Civil Relief Act by providing 30 days written notice after the next rent payment is due following deployment or permanent change of station orders. Wisconsin tenants may also terminate if the landlord fails to maintain habitable conditions. If the landlord doesn't address a material habitability issue after proper notice, the tenant can terminate the lease as a remedy for the landlord's non-compliance. One thing Wisconsin landlords need to be careful about is the state's rules on lockouts and self-help evictions. Wisconsin strictly prohibits landlords from changing locks, removing doors or windows, shutting off utilities, or removing a tenant's belongings as a way to force them out. These actions are illegal, regardless of whether the tenant owes rent or has violated the lease. The only legal way to remove a tenant in Wisconsin is through the court eviction process. Wisconsin's ATCP 134 adds important consumer protection rules to the termination process. For example, landlords cannot include certain types of penalty clauses in leases, and any early termination fee must be reasonable and clearly disclosed. The administrative code also governs how security deposits are handled at the end of a tenancy, including a 21-day deadline for returning the deposit or providing an itemized statement of deductions. For the complete guide to Wisconsin's lease termination laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for more state-by-state landlord guides.